So, friends, we have updates in two high-profile and closely watched cases. One, the prosecution of John Bolton, and the other, the seemingly never-ending saga of the Abrego Garcia case. The good news is I just sat down with Adam Klasfeld, who attended both recent court hearings, the Bolton case and the Abrego Garcia case, and Adam shares with us what he saw and what he heard in those two recent court hearings. And then we talk a little bit about where things might go from here in those two cases. So I hope you enjoy this conversation with Adam Klasfeld of All Rise News. One. All right, welcome everybody. I am really excited to have with me today for the first time somebody whose work I have followed for a very long time now, Adam Klasfeld. Adam is with All Rise News, which is a great outlet to get sort of accurate, thoughtful, gavel-to-gavel coverage of some of the biggest trials that, are playing out on the legal landscape these days. Let me tell you a little bit about Adam, and then we're going to jump into what he saw today in the John Bolton court hearing in Maryland. But so Adam is both a reporter and a legal analyst, I would say, because when I watched him, for example, on the Lawrence O'Donnell show during the Trump trial, I didn't realize that he actually appeared on MSNBC with Lawrence every night during that 6-week trial. I knew he appeared a lot because I would tune in and I would watch his reporting and analysis. What I know is that as an MSNBC legal analyst during that same time, I kind of know why I wasn't getting called from Lawrence as often as I typically would. It's because Adam was on there giving his expert observations and analysis about what was going on. And what's so valuable regarding what Adam does is he's in the courtroom. And as I say, he actually provides gavel-to-gavel coverage, which is so important, not just on the substance of what's going on in these cases, but the color commentary that, would be lost if you didn't hear it from somebody who was in the courtroom. So with that introduction, welcome to our first of many chats, I hope, Adam.
Oh, I hope so too, Glenn. Thank you for a very generous introduction. Thrilled to be here with you. Really love your work as well.
Thank you. So let's talk about primarily two cases that you've been in court on, I think, over the past 48 hours, right? The John Bolton case and the Abrego Garcia case. I am forever being asked for updates on what's going on in the Abrego Garcia case. And I was happy that you were in there and we talked a little bit about what you saw. But let's start with what you just saw. You're standing outside of the federal district court in Maryland and you just attended the John Bolton status hearing. Is that right?
That's correct. The courthouse is right behind me. And the John Bolton hearing just let out his initial status conference. So you don't expect much more than a schedule. But what was revealed about the schedule today is that it's a long road to trial. This isn't the Eastern District of Virginia's rocket docket. Though we don't have a trial date, we know that pre-trial hearings and status conferences are extending well into next autumn. There is a status conference scheduled for October 2026. We also know that, in the words of Ambassador Bolton's defense attorney, Abby Lowell, this is not the typical Espionage Act case. He didn't cite the statute, but this is not the typical case where it's a case about the possession and retention of classified documents with classified markings, as was charged against Donald Trump. This is a case over the diary entries, and according to prosecutors, they allege that the classified information contained in those diary entries that, according to the indictment, were sent to his wife and daughter for his memoirs were of such a classification level that the material cannot be viewed in a usual, what's known as, as a SCIF, which is the classified information storage facility, the sensitive compartmented information facility. So they're building a temporary one in Washington, D.C. over the next 2 weeks. They will be building one in this court a little bit down the road. And we got a glimpse of the road to trial ahead. It will be a long one.
And what substantive issues, if any, were discussed beyond the sort of time that will be necessary for the parties to prepare for trial, for a temporary skiff to be built, for people to be able to pour through and investigate the classified, allegedly classified materials that are at issue in the case? Were there any substantive issues that were raised? For example, a motion to dismiss based on vindictive prosecution.
Right. So Abbe Lowell played the cards very close to the vest. He did not say what motions he may be bringing. We do know that the information at issue, there are 10 so-called diary-like entries that are at the heart of this case. They're being reviewed by the intelligence community, and they're going through a filter team because the government believes that there may be attorney-client privilege issues involved in that. So Abbe Lowell had told the court that the motions that he will file will depend very much on what he sees from the discovery hall. Is some of the information at the heart of the case privilege? Were those privilege issues handled appropriately? Is the information in fact classified? Again, this isn't the typical case where there are classified markings on documents. This is John Bolton in his time as Trump's former national security advisor writing down notes very extensively, and that the notes themselves is this line of his note properly classified. So much will depend in terms of defense strategy based on what they see. So I think we're going to get to the substance a little bit more next year.
So it feels like the biggest news coming out of this status hearing is that we're not going to have another status hearing for almost a year, which is, in classified information cases, when you have to go through the SEPA procedures, which can be long, drawn out, and burdensome, even this one feels like it's a little bit more extended, pushed out into the future than most cases.
Right. I mean, there may be, I want to be clear, there is stuff that is happening in between now and that October status conference. There are going to be other deadlines. There are going to be other deadlines for motions, discovery deadlines, SEPA deadlines, Classified Information Protection Act. But we will see. It could very well be that the next time we are in court again in this case won't be for a very long time.
So let's shift from reporting to a little bit of analysis and talk about what we make of the Bolton case. So when I first heard about the indictment and read the indictment, it felt to me a lot like what General Petraeus did and was held accountable for. General Petraeus, some years ago, decided when after he left the military, after he left the CIA, after he left government service, he wanted to write a book. And what did he do? He shared some of the information that he had come into possession of when he was with the government, shared it with his editor, who, as famously reported, was also his paramour at the time. And some of that represented unlawful dissemination of classified material. Now, when I paid attention to that case back then, I didn't feel like it was a politically motivated case. I felt like, you take your chances if you're a former government official who was entrusted with classified material. If you want to write about it, tell stories about it, earn money off of a book you publish about your time in government, you better do it responsibly and very carefully. And it looked like General Petraeus didn't, and he pleaded guilty to 2 counts and spent
Right.
6 months on probation. When I read the Bolton indictment, I felt like this is a little bit of that. When it discussed how he was sending diary entries to, I believe, his wife and his daughter in contemplation of writing a book. To me, Adam, that feels very different from somebody who is stealing and then selling to the enemy, our
Right.
nation's secrets. Doesn't mean it doesn't violate federal law, including the Espionage Act, and I'm not discarding it. But it feels a little bit less dramatic than many of the espionage cases, including the espionage case I handled as an Army JAG prosecutor out of Desert Storm, where there was some really nefarious intent going on there.
That sounds exactly right. And if you look at the indictment, it says, for example, that it's all about these diary entries, and that the information at the heart of the case isn't necessarily about what was published in this book. It is about essentially what hit the cutting room floor of this book. So there's a lot we don't know about it. I didn't, in my reading of that indictment, see any allegation of an improper motive. There is that hasn't come up, of course, in court. Other than, of course, whatever money he made on the book, but they don't accuse him of having any sort of selling information to the enemy. This isn't the case like with Donald Trump, where he refused multiple commands to return the boxes of documents marked with classification markings. And to your point, yes, there seem to be many parallels with the Petraeus case. I would also say that this is a case, being in the District of Maryland, there was no purge of the U.S. Attorney's Office that preceded this case, as there was in the Eastern District of Virginia, where I was a couple of days ago and you were a couple of days ago. That this was, even from the earliest reports before this was charged, said to be a case that the prosecutors within this district believed had merit. We will see what happens on the road to trial, and it will be a long road to trial, but it seems in substance a bit different, even though it fell, of course, in close succession with the Comey indictment, with the James indictment, and with John Bolton being such a prominent critic of Donald Trump. Of course, that raised suspicion, raised a lot of eyebrows, but the difference between the two districts is a little bit glaring at this time.
So before we move on to your update in the Abrego Garcia case, which I'm really interested to hear about, let's finish out the Bolton discussion with this idea of the possible defense of vindictive prosecution. So, one of the things that you just mentioned is the District of Maryland, the U.S. Attorney's Office, which is an arm of the Department of Justice that handles federal prosecutions in Maryland. We haven't heard anything about a purge, wide scale purge by the Trump administration of, people who are perhaps not sufficiently devoted to Donald Trump's agenda as opposed to being devoted to the rule of law and the Constitution, which is what we federal prosecutors are required to be devoted to. So let me start with the idea of vindictive prosecution, because what we have learned is this is a long running investigation in the Bolton case that culminated with this indictment. It was being investigated as early as the first Trump administration. Reporting is it was investigated through the Biden administration. But what we know definitively is he wasn't indicted during the years the Biden administration was investigating it. And of course, he ended up being indicted when Donald Trump retook office. To me, it feels like there may be a straight-faced motion to dismiss based on vindictive prosecution, but I'm not sure it would be a successful motion. Of course, nobody is sure because we don't know all the evidence. But my analysis would be, if the Biden administration investigated it and opted not to prosecute, not to bring an indictment, then that suggests that maybe the Trump administration decided to bring an indictment based on a vindictive motive rather than the evidence. However, playing devil's advocate, it may very well be that the Biden administration decided this was really more of an error of judgment rather than of nefarious intent, wanting to harm the national security interests of the United States. He may have technically violated the law, but it's what we call a de minimis injury. He didn't do any harm to the nation. Now, that doesn't mean he can't be prosecuted. It just means maybe the prior administration decided it wasn't a case worth bringing. And what I will add is I can't tell you in my career as a prosecutor how many times I declined to bring a case because there was de minimis injury, minor injury, and we had 1,000 other cases we were pursuing. So resources do become a factor in our prosecutorial decisions. And I want to throw one more thing into the mix before I throw it back to you for your thoughts on that. I was heartened to see that the prosecutor in this case, at least the one who appeared in court today, the Assistant United States Attorney, Thomas Sullivan, has been with the Department of Justice for a very long time. He is a federal prosecutor in the Maryland office and has been for more than 12 years. Before that, he was a federal prosecutor in EDNY, the Eastern District of New York, reportedly for 4 years. So I am comforted when there are career prosecutors handling these kind of cases and making these prosecutorial decisions, as opposed to somebody like Lindsay Halligan, who has been installed at the last minute to bring charges against Trump's perceived enemies before they timed out. Anything in that mix that catches your attention?
I think you're right on the money with all that analysis. I will say, just even looking at the dynamic of what played out in court and with that prosecutor who you mentioned, the whole dynamic resembles an pre-trial criminal proceeding that I recognize. When I walk into Lindsay Halligan's pre-trial criminal proceedings with James Comey, that dynamic, the dynamic of what goes on from the prosecution table and the defense table, that it's the funhouse mirror of what I'm used to. This was a usual, sometimes routine, sometimes housekeeping matter, pre-trial proceedings. The relationship between the government and defense attorneys are cordial. They are working toward the common goal of getting on the road to trial with both sides being prepared. To your other points, yes, I think at the heart of this case may be prosecutorial discretion, and the prosecutors appear to believe in this case vis-a-vis Bolton. But I think to your point, absolutely, there could be a vindictive prosecution motion if one was not mentioned in court today. And I agree with you that even if there is a basis for the reason that you said, the prosecutorial discretion of the Justice Department under the Biden administration was not to bring this case for whatever reason, and that may go to such a motion. But to your point as well, we have discovered already in Trump 2.0 that these vindictive prosecution motions are very difficult, but not impossible to win. One of the cases that I'm following, and this will make for a good transition, the Kilmar Abrego Garcia case. And he has brought a vindictive prosecution motion that is going to an evidentiary hearing in Nashville, Tennessee. And even getting that far, the burden is shifted to the government to prove that the case was not brought for a vindictive reason, that there was a valid reason to bring this case. So that showed a substantial victory. On the other side of the coin, that shows how difficult vindictive prosecution motions are to win, is the case of Congresswoman LaMonica MacGyver in the District of New Jersey. She is the congresswoman who had visited an ICE detention facility in Newark as part of her oversight responsibilities. And during that, there was a melee when the Newark mayor, Ross Baraka, was being arrested. She filed a motion for vindictive prosecution and lost that motion because in the case of Kilmar Abrego Garcia, you had a circumstance where Todd Blanche is standing up in front of Fox News and saying, we brought this case because a judge questioned our decision to take Kilmar Abrego Garcia out of the country. That is direct evidence. And with Comey and Letitia James, what you have a Trump post on social media. It might be more difficult for John Bolton in this circumstance to get that level of evidence that's required in such a motion. It's so difficult. I've rarely seen one succeed. As a matter of fact, the first time I've ever seen personally in a case that I'm covering a vindictive prosecution motion advanced to an evidentiary hearing was Kilmar Abrego Garcia. It shows that it's possible in Trump 2.0, but it is still difficult.
And it's such a great point. In my 30 years as a prosecutor, I don't think I ever saw a vindictive prosecution motion made. I know I never saw one go to an evidentiary hearing. I can't recall of ever seeing one made. Um,
Right.
and then we'll finish up on the vindictive prosecution. And I want to hear about Abrego Garcia. My sense is that if it was a very weak case or a de minimis injury case, and the Biden administration said this is not worth pursuing, and the only reason it got brought by the Trump administration was Donald Trump's hatred, expressed hatred and determination for revenge against one of his most vocal critics. If that was the sole reason that resulted in the change in the prosecutorial decision, that feels like a bit of uncharted legal territory that the judge will have to navigate and see whether that's enough to dismiss based on a vindictive prosecution claim. Anyway, lots of interesting things as this case plays out. But now, tell us about a case that has really riveted the nation for so long now, the Abrego Garcia case, and what you saw in Judge Xinis' court, again, there in Maryland.
Right. So right behind me again yesterday in Judge Xinis's court, the evidentiary record was closed in the habeas corpus case. And that's a case to free Kilmar Abrego Garcia from immigration detention. And so to take a step back, there are now two cases involving Kilmar Abrego Garcia. You have in Nashville, Tennessee, his criminal case that began after, of course, he was whisked out of the country in March of this year to a terrorism prison in El Salvador, where he was tortured. After a file, so there were actually three cases because after that occurred, he went to this court, the first case before Judge Xinis, where Judge Xinis ordered his return to the United States. It was upheld all the way up to the Supreme Court. After 5 orders, the government returns him to the United States by charging him with smuggling immigrants. And now, while that case is going on, the government is apparently trying to short circuit his ability to defend himself at trial by deporting him once again out of the country. There have been several efforts. We're on effort number 4. The first effort was to send him to Uganda. The second effort was to send him to Eswatini. The third effort was to send him to Ghana. All 3 countries, of course, he has no connection to, but none of them actually wanted to accept him into the country. They hadn't agreed to it. As a matter of fact, we learned the Trump administration didn't even approach them about it before announcing it publicly and in filings. So now the plan is to send him to Liberia, a country with a spotty human rights record. You had the Trump administration attesting to the wonderful human rights record of Liberia at the same time that their State Department reported all the extrajudicial killings and things of that nature. What happened in court yesterday, it appears that Judge Xinis is very skeptical that the government has ever obtained a final order of deportation. The government's argument is that an immigration judge had rejected all of his defenses, and that in fact amounts to a de facto final order of deportation. But there is nothing on that document, and Judge Xinis said this repeatedly, that says that Kilmar Abrego Garcia must be deported to X country. And there is one final wrinkle that I should point out. I would be remiss if I didn't point out. When Kilmar Abrego Garcia won the right to pretrial release in his criminal trial, he was offered a plea deal by prosecutors that if he agreed to plead guilty and after serving what would have been a brief sentence, to accept deportation to Costa Rica before he was released from pretrial detention, they would send him to Costa Rica. They have withdrawn that offer from the table as soon as he availed himself of his right to defend himself at trial, as right to pretrial release that he won over the course of multiple hearings and motions. And now, knowing that he has the full weight of the federal government that wants to send him to any faraway human rights abusing place on the global map, his attorneys have in this very court, multiple times said he will go. He agrees to be deported to Costa Rica. The U.S. government has not accepted that arrangement anymore. They revoked that arrangement. That Kilmar Abrego Garcia's attorneys naturally say that they are doing that because the only reason for Costa Rica was to strong arm him into a guilty plea. So the Judge Xinis seems very skeptical that there's a final order of deportation. And if she finds that, that's a ball game. She said, we're done if she has that finding. And she may also find that the prolonged detention violates Supreme Court precedent against indefinite immigration detention in the Zavidas case.
So a couple of procedural questions. Did she indicate when she might have a ruling or when the case is next up in court?
She did not. She did indicate that the evidentiary record is closed. She has taken her time. This has been a very protracted process. Just to give you an idea, there have been 4 evidentiary hearings where she has ordered a Trump administration official with knowledge of the matter to testify. All time, each of these 4 times, the official that she called for testimony did not have any information that was relevant to the subject of her questioning. That is the subject of a pending motion for sanctions that she has not yet addressed. So I mention this to talk about the deliberation with which Judge Xinis has approached this matter. She knows that this is a case on a parallel track with the criminal trial, and she also knows that she there was a telling remark, I should say, that she gave yesterday, Glenn. She had said that she used an expression that I actually wasn't aware of at the time. She said, "We'll eat the elephant one bite at a time." And that's how she's approached this case. So I wouldn't expect a very quick deliberation with this. She has been sitting with this case for a while, but it does look like she is sharply skeptical of the idea that Kilmar Abrego Garcia has a final order of deportation. And if she believes that, there is a significant possibility that he could be ordered released.
And is there any contempt proceeding that might be in the offing? I know we heard about that early on when it looked like the government, the prosecutors, the DOJ attorneys were playing some pretty extreme games, not being entirely candid with her. And then I think I heard maybe your reporting yesterday where there was I think a DHS representative who provided a declaration, kind of like a sworn statement, an affidavit. And then apparently it kind of unraveled during the hearing where there was a paragraph in there that he claimed, well, you know what? I didn't draft it and I don't know what it means, to which I would respond, well, then you shouldn't have signed that declaration. And that conjures up notions of possible contempt. Was there any discussion of contempt yesterday?
So I think that's in the pending sanctions motion. It didn't come up in court per se, but I wouldn't be surprised because the issue generally has come up in this litigation because the throughout these proceedings, she has ordered the government to provide a knowledgeable witness to the witness stand. The last time that I was here, and not referring to yesterday, the time before that, the last evidentiary hearing, she said the baseball, phrase, 3 strikes, you're out. Well, the government just got its 4th strike yesterday. So I won't, I would not be surprised if the Chekhovian gun of contempt that has been hanging here since early on in the Kilmar Abrego Garcia case returns again. At minimum, there is the possible revival of the sanctions motion.
Feels like we're in extra innings in the Abrego Garcia case.
We are.
Now, let me just be clear. He's still in detention in the deportation case, correct?
Correct.
Even though he has been ordered released and was released in connection with the prosecution in Tennessee. And let me just make two observations, and then we'll finish this up. First of all, I understand using benefits, potential benefits, as part of the plea bargain process. That is routine in virtually every case when we are negotiating possible dispositions, guilty pleas with defendants. However, if the government was willing to deport Abrego Garcia previously to Costa Rica, I'm sorry, it feels a little vindictive ish that they have completely taken that off the table when they are certainly determined to get him out of the United States by hook or by crook. So I wonder if that doesn't breathe a little bit more life into his vindictive prosecution claim down in North Carolina. But let's finish up with this. The minute I read the Abrego Garcia criminal indictment that was issued by the Middle District of Tennessee U.S. Attorney's Office, having drafted and reviewed more indictments than I can ever recall, I said, this is a garbage indictment. I may have used a stronger word. And I believe that DOJ wants to run away from that prosecution by any means they can because they don't want to go down in flames, nor do they want to have the judge, I think it's Judge Crenshaw down there, rule that indeed this was a vindictive prosecution and grant the motion to dismiss the case, perhaps with prejudice. So I suspect that DOJ might rethink, or DHS might rethink, that no Costa Rica for you deportation decision, but we will see perhaps soon enough.
I think that's correct. I mean, one has to ask, if they are so confident that Kilmar Abrego Garcia has committed these horrible crimes, why are they fighting so hard to avoid this trial by deporting him? And why are they pointing to different spots on the global map, seemingly in a pressure campaign to coerce him into pleading guilty to those offenses? And so I will say I will be going down. I have been going down to the Middle District of Tennessee and Nashville, and I will be there again early next month for that vindictive prosecution hearing. One of the things that came up in the motions in that case has been the fact that, as widely reported, the day that he was indicted, the chief of the criminal division resigned. That has come up in the papers. We'll see if it comes up during the hearing. We will see if the defense succeeds in getting Todd Blanche up on the witness stand as they have requested. So it could be a very interesting hearing early next month.
And that chief of the criminal division is a former colleague of mine who worked previously at the DC U.S. Attorney's Office. So that is a backstory I'm pretty familiar with. And we'll see how it plays out. I just don't think any of it in the Tennessee case ends well for the Department of Justice. But listen, thank you for jumping on with us. And this is why everybody can see that somebody who is willing to do gavel to gavel coverage and talk about what's really going on in the courtroom is so important and valuable in helping us understand what these cases are really all about and what's actually happening. So, Adam, thank you for jumping on. I am going to be calling on you early and often if you're willing to bring to life for our viewers what's going on inside the courtrooms.
Absolutely. Anytime, Glenn.
All right. Take care. Thanks, everybody.
You too. Have a good day.